future damages future harm could be awarded in damages. That's super unusual. Courts hate to speculate about this kind of future harm, this is really unusual. So what it means, and so the reason we talked about it at Mid-Atlantic Conference over the summer is that it was in the context of cybersecurity insurance. Because what does that do to cybersecurity insurance claims if we can calculate damages based on future harm in the data breach? It's going to raise the costs, and it's probably going to affect how a cybersecurity insurance company writes a policy and how you may want to buy your policy. So it's a pretty big deal, and so it's worth noting. I kind of put it on the Supreme Court slide just to kind of be able to talk a little bit about what, the fact that they denied cert didn't mean they affirmed it. It just meant that they didn't overturn it. So, FTC. Most of you may know this already, but it's worth talking about a little bit. There were two cases, and these are older, 2015 and 2017. FTC in the last couple of decades got into the privacy enforcement through unfair and deceptive trade practices. And so as that work continued, they began to talk about cybersecurity as and the risk and the cybersecurity threat as an unfair and deceptive trade practice. In the Wyndham case, Wyndham is a hotel chain, huge amount of volume of people's data. They had 3 data breaches. And the court found, you gotta do something, that Wyndham failed to use readily available security measures like firewalls. They didn't even have firewalls. So,
Gross negligence.
Reasonable.
and that was that question of, okay, so, but keep in mind, FTC is under unfair or deceptive trade practices. So what they said was, it was a deceptive trade practice not to have cybersecurity. So it's kind of a unique theory, or a unique application of this. Because Wyndham sued, look, we were a victim. We didn't try to deceive anyone. But what the FTC said is you must protect customers' personal information. And so it was a pretty broad order that the FTC brought. A couple of years later, and this case is really weird. You got a small testing lab. They do blood work and what have you. The billing manager on one computer, their computer, has a file sharing program that's IT didn't know that. Security company comes in, finds the file sharing program, starts hunting around that computer, and finds 9,300 customer records of their test results. Steals it, tells the company about it, offering their services, which one level is kind of icky, but another is kind of a really great marketing option.
I have a comment when you're ready for those.
That's fine. But it was just kind of bizarre. And so when the company denied them, they sent the file to the FTC. So it's really a bizarre set of facts. The FTC then went after them with both barrels. They broad failure to protect customer data. The company goes out of business. The litigation continues. And what ends up happening is the court says, you have to make your enforcement specific to the threat. This is one computer, it was in violation of the policy, your enforcement order was too broad. And so, taken together, what you get is, FTC has power to regulate cybersecurity, but it has to be proportional to the risk. And so I think that's important to understand because in a lot of cases, FTC wants to go broad. because they really do feel, especially in the privacy space, they really do feel like the central driving force of privacy. Cybersecurity has been part of that, but it's not unlimited. Other regulatory agencies. SEC for public companies has been involved in cybersecurity over the last decade, much more so. And so there's requirements to have cybersecurity expertise on boards. They're becoming, SEC is asking for more information about cybersecurity risks and incidents in their disclosures. So the thing I point out to you is this is from 2018. You must inform investors about cybersecurity incidents and risks. So incidents make sense in terms of the business, but even risks. So we're talking about really looking at the future and having that discussion. So if you're a CISO and you work for a public company and you are not having talks about what your risk profile is with the senior leadership and even the board yourself, that's something to keep in mind because SEC is really driving this. So, so I highlight it for you to be aware of, and there's a lot of materials on the SEC website. This is just a guidance document that they put out, but it's in the Federal Register. For those of us who work for government contractors, and I do as well, DoD issued this guidance earlier this year, and it was based on the 2016 requirements to manage controlled and classified information in contractor systems under the NIST 800-171 guidelines. DoD published this was sort of it was a request for notice, request for comment, saying, are you having problems? We want to hear from companies about their implementation of the 800-171 guidelines. And what has not yet been implemented, which is, by the way, was due December 31st, 2017, and this is 4 months later. So there does seem to be a tacit admission from the DoD that perhaps they went too far too soon. There's also a request for information. Please share with us your experience. So that bifurcated role that I was talking about much earlier. But there's a mention that there's challenges with meeting the requirements from both sides. But the question is, and it's a debate that your legal departments will have about how much to share and what to share and whether to participate in a voluntary request for comment. If there's an advantage to highlighting the implementation challenges that would cause DoD to change the rules and kind of relax or maybe sort of make an easier on-ramp for these requirements, that would be great. But they also have the power to regulate you or regulate government contractors. So there's sort of this weird balance of having to adjust and see, how one wants to participate in that. So I mention it because it's 2018, but it's also, it really highlights that bifurcated role. Europe. It was, the implementation date for GDPR was May 25th this year. A lot of people still struggling with some of those. Privacy Shield was the current U.S. data sharing scheme that Department of Commerce negotiated with the Europeans. It's being sued in European court and may go the way of safe harbor. It's hard to say. But that's sort of currently going on in the background. The thing I would want to point out for you for my data security GDPR, it's all privacy, it's specified certain data, has a very broad, expansive notion, and a lot of people talked about the privacy elements, but the data security elements have been less discussed. In fact, I may write an article about that. The four things I want you to know is that data processing is a broad term, and it's basically anything you do with data. So if you're dealing with European personal information, that whole processing, you're going to fit in some way. So look at that, those verbs very carefully. There's this idea of pseudonymized versus anonymized data. And the use of pseudonymized as opposed to anonymized assumes some kind of latent traceability. So kind of think about it, we really think about especially encryption, and then if we strip out the personal information, the personal from the information, we've done our due diligence. There's sort of this implied lingering liability that's attached in the European model, in my opinion. There's a general security requirement, Article 32, and it's you must have reasonable security. It's a CIA triad. It's nothing more than that. So there is a floor, and they don't get into, this is that whole reasonable security feature kind of, we're going to require you to do something, but we're not going to specify what. But it's there. And there's discussions of monitoring and profiling in kind of a big data AI context that I think will come into a lot more discussion when you look at like drones and kind of, there's a lot more surveillance of people in public spaces, sometimes in Europe. So there's much more laws. GDPR implements stronger provisions for that kind of profiling and monitoring. And so those are the things I would highlight for you in terms of data security. If you're dealing with personal information and processing it, there's a whole lot of trying to figure out whether noticing consent is required, whether you can go under legitimate interests of the business or performance of a contract to get authorization for the data transfer. So there's a lot of that kind of analysis still being undertaken by companies. Everybody's updated their privacy policy, but how does it actually work? So more to come. I will say that the big thing is, the thing that has surprised me the most about GDPR is that there hasn't been a lot of action yet from the data protection authorities going after US companies. And so I'm curious to see what that actually starts to look like. So when I talk to you about Congress, there really hasn't been that big a change in this Congress over the last 2 years. 2 acts that were passed this year. One told, Congress told NIST, hey, you need to have a small business cybersecurity framework. And we've already given you money, so you do it out of your existing funding. Does that move the needle? Not really. For small businesses, it might be a great opportunity to participate in the NIST process as they develop that framework. But basically, Congress said, NIST, you do it. So it really didn't change it. There was a recent, super recent Cybersecurity Infrastructure Security Agency Act for DHS. Congress loves CISA as their acronym. And it reorganizes the cybersecurity requirements within the agency, but it doesn't have any impact outside the government. Right now it's just, it may be mobilizing capabilities, it may change priorities, but none of that is really visible from the act. So I say no big changes. In the previous Congress, so 2015, 2016, there were a couple of things worth noting. The Cybersecurity Information Sharing Act was a government framework to share cyber threats with businesses. And again, here's an opportunity to share. And the question I have is always, okay, it's a voluntary program right now, but what happens if it becomes mandatory? And I'm always, as a regulatory attorney, on the side of representing businesses, I kind of act like a defense attorney for regulatory endeavors, so I'm always suspicious. And then the Trade Secrets Act creates a federal right of action for trade secret cases. You may say, okay, big deal, but what that means is you don't have to sue in state court, you can sue in federal court, and that gives you a lot of different options that you wouldn't have otherwise. So it's worth noting that a lot of these there are a few changes, nothing big. Here are the risks I think that are on the horizon. If you ask me to sort of peer into a crystal ball, we've got this certified ethical hacker army that we're building, private industry with an offensive capability, and the risk is really in hacking back. One of the questions that one of the questions that was posed to me at the start of this discussion about doing a presentation was, what about the Hack Back bill in Congress? That is probably going to die in committee, but this is a risk that's coming, whether or not it's going to happen eventually. We're going to have a case or a series of cases where we've got people who may respond. So yes, it's illegal. Yes, it's a violation of the authorized access on computers and the state versions of those laws. But we're building an army. Botnets, we talked a little bit about this already in terms of how to assess liability. IoT, talked about that in terms of California. Is California ahead of its time, or is it right on time? You know, we get into this whole idea of, is it really good? Like, law does not want to influence business, so it tries to stay out of it. But with this whole idea of wearable tech, time and location information, if cell phones are homing devices, what about Fitbits? We had a presentation in January. Amber Schroeder talked about a murder case where husband murdered a wife, and they convicted him based on his wife's Fitbit data. So this is there. This is definitely coming. What I will say about blockchain is that Bitcoin, the whole focus of it is being decentralized, and our whole financial regulation is based on centralized regulation and enforcement under the Department of Treasury. So if you're in this, if your financial regulatory environment is very centralized, you're trying to disrupt it, you've got two things that might happen. One is you may not have the protections you need in a financially for, like FDIC protection in the case of fraud. So then the question becomes, what happens if something bad happens? How do you process it? Because we have to go, the law looks backwards, so we have to look at what are the existing structures. So Bitcoin doesn't fit really well into that yet. And it will be interesting to see, especially with the rise of cryptocurrency hedge funds and different financial instruments, you're going to have broader consideration, certainly under SEC as well. Supply chain and new contracts. I find this fascinating as an attorney who codes. There's the discussion I heard, supply chain, they're looking at implementing it for the Kimberley process for diamonds to avoid conflict diamond transfers, which I think is cool. I'd like to see how that, I've been kind of watching it because I want to see how it evolves. The biggest challenge with implementing blockchain is getting all the nodes set up so that you have a critical mass to actually build a community. In the e-contract setting, I've heard blockchain being used for things like managing escrow and real estate transactions. And what I thought was cool about it is if you can identify sort of those transactions, the legal triggers, and put them into software, what blockchain will do is pay escrow and do all the processing without an attorney. So what happens when software puts attorneys out of business?
It's not gonna happen. It
You
might
never
put
know.
some attorneys out of business.
It's definitely gonna change the role. Traceability and integrity. So the big issue with blockchain is if you have an unintentional, unplanned forking, like Ethereum, that's the big risk. So if the whole thing is built on you can rely on this and it's independent, really nailing down the risks is key. And so that's where I'm looking at, how we interpret blockchain in the law is going to be based on these types of risks. Going back to what we built, the first part of this is this whole cybersecurity landscape. What I will offer is that these are perennial issues. So individuals, there's always going to be